I move we deny the request.
I'll second it for the sake of discussion.
Okay, it's been moved and seconded. Discussion, please.
I would question if it's in the best interest of the public to actually decide this one tonight. I know we have it in our code to decide by the second meeting in December. In the public interest in the past, we have delayed. And that happened, was that just last year?
I believe we delayed for weather.
For weather, because people couldn't make it at that point in time. It was in the best interest for people to come and be able to participate. In this case, there are a number of concerns, really. One is just partly on the applicant's part, not showing up at the hearings, so unable to answer questions, I guess, which was unfortunate. Then also hearing that there's an opportunity for settlements between litigants, because this is taking several paths, not just this one. It's going through the courts, and there's a possibility of settlements between people that are concerned about this project and IMQ. And then also future decisions coming down the pipe that may influence our decision. So in a lot of ways, I feel like this really isn't right yet for a decision. So I think in some ways it'd be unfortunate to decide at this point.
Well, we could put it off until the next round. This would, meaning would take a decision would be taking place next year at this time.
Yes, you carried it over. Last year, of course, there was an emergency, so in view of that, we extended a month. 2 years ago, per the applicant's request, we carried an application over to the following year, put it in the next cycle, and considered it cumulatively with other amendments.
What was your reason, 2 years ago?
At the applicant's request, in view of the environmental review had not been completed, which was the statesman proposal in view of the non-project EIS.
Since this is the only one of this type in this batch, is the cumulative effect that big an issue? Really, that's everything was, in terms of making decisions on all of it.
It's at your judgment call on the cumulative effects, and you can say that this was either the more significant or the least significant of all the applications in terms of its impacts, both environmentally or non-environmental impacts for the community as a whole. Your public interest statement is accurate. We have legislative discretion. Robert's rules allow you to table. That's one idea. You can carry over. You can table until a further date, or you can make a decision.
That way, if we tabled, so we could do it, say, 30 days or 60 days, get an opportunity for things to work their way through on the other issues before we make a decision. I hate to make a decision legislatively and then find out if the court decision went the way I thought people would later on.
When did this come up?
Well, that's a problematic thing too, in terms of appeals, they can take, they don't have to.
Well, I think that there are some elements in the impact analysis that are pretty powerful. Page 2-48 of the Comprehensive Plan Amendment docket, for example, Table 10. One of the questions is whether the proposed amendment reflects current widely held values of the residents of Jefferson County. And we've received, I I would say at this point, at least 60 emails and letters, and testimony from citizens indicating vehement opposition to the approval of this MRLA. They are not at all convinced that the applicant would do what is necessary to protect their property values, the ambiance of Port Ludlow, that they would be cooperative players and cooperative neighbors. There has not been evidence that the applicant would be cooperative in terms of making sure that mitigation is done for county roads. I think it's particularly important to note that this is, even though one of the staff recommendations was that the MRLO be at least 1/2 mile from the NPR, this does not guarantee that the rights of the citizens would be protected.